Okay, abusu breaking news bi aba eno na ya project say e de ato ye screen no enchen e de amamano former Chief Justice head to court to challenge her removal. Abusu eye former Chief Justice Torkorno or say ne removal na de onte ase ne entiase echna intino wasanso a file for application area akwa kopie mu wo court say 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 ne removal no or challenge ne removal na kwan aye fa so e de eyi na di no ono de ontiase ne entiase echna upon all the allegations, scandals around a year, former Chief Justice Torkorno, ono de osini nyina enye nokre intino say ye call into the right procedure. No, ojine hu di say onye guilty. Omuna omubu an say by force guilty de ono de ojine hu di say onye guilty. Abusuya into any breaking news ewo hwa ya project say e de ato ye screen no enchen e de amamono Ivan Chidin Simbi ababe tudwa about her removal process. Mommy enko na yenko nkoti ensema Ivan Chi e de tudwa unsubscribe ya subscribe like na share ma afofron so ensa into me enkabia ha Ghana Politics Avenue so medamase.
Yes, from where I sit, I think was appropriate because the constitutional process was activated, it was followed through, and at the end of the day, per the dictates of the constitution, whatever the recommendation that the committee comes up with, the president is enjoined to go ahead with it. That is exactly what happened. Yes, I've listened to a lot of concern being expressed by people regarding the future of our democracy and other issues, but for me, where I sit that the president received a petition from a Ghanaian who felt that certain things had gone on in the judiciary that were inappropriate, and a petition was sent to the president. The president is mandated by the constitution to forward the same petition to the Council of State, and that is exactly what he did. The Council of State went through the petition, and they were able to establish merit in the face of the various grounds that has been stated under Article 146. And then the committee was set up. The president signed a warrant. That is a discretion that only the president can exercise, because per the constitution, if prima facie is established in that situation, the president can sign a warrant, and that is a discretionary power only the president can exercise, and he did so. And President Mahama wasn't the first person to do that. I remember when Justice Derry and 4 others had issues with ANAS, and prima facie was established in their case, President Akuffo signed a warrant suspending them pending investigation. When the investigation ended, the committee recommended that they be removed. So for me, this is not a novelty. It has been done before. But what I find quite mind-boggling was some of the disposition of the Chief Justice in reacting to some of the situations. You mean the former Chief? Yeah, former Chief Justice. Right. I was quite shocked with some of the reactions and some of the comments that she was making. First of all, when the president forwarded the petition to the Council of State to establish merit and to establish what they call the prima facie, she came out asking for a ruling from the Council of State. And I'm like, Council of State is not an adjudicatory body. They are not lawyers. It is not an adjudicatory process. What they are supposed to do is to review whether there is legitimate grounds for that particular petition. Because don't forget that the Constitution states 3 grounds upon which the Chief Justice can be removed: infirmity, both body and mind, misbehavior, and incompetence.
Stated misbehavior. Well, I have issues with that, but anyway, just
stated misbehavior. These are the 3 grounds. So because the Council of State is not an adjudicatory body, they cannot go into the legalities and the constitutionalities of the petition that has been submitted. So they only situate the petition within these 3 parameters to see whether they are competent in the face of the Constitution, and that is exactly what they did. So to demand for a ruling from the Council of State, I found like this is not an adjudicatory body. So what ruling are you looking for? You understand? And you see, over the years, I keep telling people that we are not growing as a country. If you look at the Constitution, that provision, it says the president should forward the petition to Council of State. The processes and the guidelines that has to be followed to ensure that the Council of State arrive at a decision that has never been written anywhere. There is no procedural arrangement that has to be followed. So there is some kind of ambiguity hanging that particular process.
You feel we should review that provision in the Constitution?
As I keep telling people, there are several portions of our Constitution have outlived their usefulness, and we really need to approach them radically and review.
So then we're not fair to the former Chief Justice then?
No, but she was Chief Justice. She saw these things. She didn't do anything. And some people in the past...
She's just a Chief Justice. I mean, she's not into
no, but if you and I sitting here can just look at the Constitution and see there are several portions of it which have outlived their usefulness, a Chief Justice ought to have known it. You understand? Because
and do what about it, really?
No, you say democracy is a growing process. We can activate a conversation and have some of these things. Before the election, there was this social media argument that we needed to do something about our Constitution. Now, President Mahama has set up a committee. They are going through the Constitution just to have it reviewed, because constitutions are supposed to be a living document reflecting daily aspirations, wishes, and whatever that is happening within the country. So always you need to update it. It must grow.
Here's the thing. There's another former Chief Justice, Akuffo, who's not happy about the decision. In fact, she's gone public on
Yes. That. She's an individual just like any other person, and there are a lot of people who are not happy about it. So for me...
But she testified, and her point is, look, if you look at the threshold, this is not something we should be very big on. It's just about travel, you know, and some other few.
No, you see, you can't brush some of these issues aside. For instance, if the law says that if the Chief Justice is on a private trip, you need to go with the security. I think there is a reason for that, because the person in question is Chief Justice. Traveling out there, there is a national security implication if she is abducted today and being forced to do anything, you understand? So there is a reason why a security officer must follow you. So at the preliminary stage, in case something is to happen, maybe the person to a certain extent can do something. You Chief Justice cannot waive that and ask the person to sit back and take your doctor along and be paying that person per diem. You see, one thing people are not looking at, integrity at that level must be discharged at its uttermost. You cannot impugn it, you cannot disregard it, because this person in question is the administrative head of the judiciary. So you are some sort of an emblem that everybody should be looking at. So you cannot be brushing aside some
all
of
these points you're making. Yes, they are fine on paper, but are you sure there's no politics in this?
I'm not sure. You see, I've gone through the process, and then I asked myself, were any of the processes circumvented? Has there been any constitutional infraction? Has there been any misapplication of the law? And I have listened to a lot of lawyers speak. None of them has been able to pontificate to exact constitutional infraction that has occasioned thus far since the activation of this process. You understand? Yes. Beneath it, you can have this, you can say maybe there is some malice, some mischief beneath it, but the question is, can you prove it? Because the whole process has been in line with the Constitution. And for me, that's my worry. And there is one thing that I'm very much concerned about. You see, I refer to the posting of the sacked Chief Justice. She went to court and prayed the Supreme Court to give her a green light so that the whole process should be shown on TV. And I'm like, what? Because there is an explicit constitutional provision to that. And the Supreme Court doesn't have power to vary a constitutional provision. Justice J.C. Amadou Tanko made it clear in his ruling that you are asking us to do the impossible, because we do not have the power to vary constitutional provision. That is explicit. There is no ambiguity hanging on that particular clause. So a Chief Justice who should know better, know these things, will go to a Supreme Court and ask them that the proceedings should be shown on TV. Sometimes it beats my imagination. And when that particular option was refused, then she carried the whole petition to TV and did a press conference, creating another legitimate ground for her removal, because you've breached a constitutional provision. Article 140 says 8. It states that the whole process must be held in camera. So if you do some of these things, so for me, I think she didn't help herself. And in the course of all these things, instead of focusing on defending the critical issues in the petition, we were dabbling in trivialities, saying things that were unnecessary, procedural breaches and those kind of stuff. And I think
it wasn't helpful.
From where I sit, I think nothing wrong has occasioned. I have listened to a lot of people who argue that we need to tighten the Constitution so that in the future, no Chief Justice can be removed. Let me sit here and make it clear that there is no Constitution under the sun that grants absolute power or absolute tenure to anybody under any Constitution under the sun. There is a reason for that. If you are even the most powerful person in this country is the president, there is a window for his removal. Because we are human beings. We can go anyway at any point in time. So we cannot create an iron shield position and put somebody there. What if the person decides to do things on his own? You understand? So I think what we should be focusing on now is to making sure that whoever becomes a Chief Justice will go through a proper mill. So by the time the person comes out, you know this person is fit for that particular job. I will not be exhibiting these sort of things that we've been seeing in recent times.
And Fati, you are a lawyer as well. Divided legal opinions on whether or not her removal was appropriate. In fact, there are some who are bringing on new perspectives, indicating that, look, even her removal was just as Chief Justice. That's part of the political argument that's being made. The legal argument that's being made. That, look, you are removing her only as CJ. You're not removing her as a judge of the Supreme Court. But, let me get your legal thoughts on her removal.
Okay, first of all, blessed, of course, I've been clouded by two pro-government activists. Of course, Nana, of course. Nana is a presidential staffer. I do not expect her to speak a position that contradicts the position of the president or the ruling party. It will not be fair for me to expect that from her. And then Ivan is a known NDC activist. I do not expect his position to contradict. Oh, of course, I mean, let's have integrity. No. So no, but I respect their respective opinions. But I want us to go into this conversation appreciating the context of this case. And over the period, there has been a bizarre relationship between women at the bench and the NDC. PNDC, NDC, quite a bizarre relationship. In the 80s, of course, we had a situation whereby a female justice of the High Court, a breastfeeding mother, was lured and murdered for doing her work. We had a situation where Justice Georgina Wood was the Chief Justice of the Republic. And then three gentlemen, popularly known as the Muntie Three, threatened physical assaults. The court charged them with contempt. They were imprisoned. The president at the time in 2016 granted them presidential pardon. And even before the pardon, ministers of state, including the female ministers at the time, had gone round to solicit signatories to petitions for their removal. That threatening assault, saying you will do something to them, should not warrant any incarceration. And I'm talking about the same proponents of rule of law who today can pick TikTokers for saying things on the live and then causing their arrest, and arrest somebody and go to someone's house and bundle him for posting a picture or video on social media. And then we came to Justice Torkorno. From the jump, I knew she was a goner because this is a political witch hunt. And we have to call it for what it is. And why is it a political witch hunt? There is another trend where anytime the NDC goes to courts and they lose a case, they tag the Judiciary Unanimous FC. They call them names. Even though some of the justices who constituted the members of the panel were appointed by the Mahama One administration, they will still say they don't trust them because this is the erstwhile government. But anytime they win a case, like they won in the Akuffo case, they say justice has been saved. And I have done 2 presidential election petitions as a frontline communicator for the NPP. So I understand what female justices have gone through in the hands of the NDC in my lifetime. Now, there is something called prejudice. Even before these petitions, and I'm not even talking about the 3 and the last 2, I'm talking about the Professor Asari's first petition to the
one that was done when you were in power.
Yes. Even before that petition came out, anytime leading members of the NDC were on radio or TV, all they said was that when we come to power, we are not going to work with this Chief Justice. The only time they supported this Chief Justice was when they were communicating a justification for why the NDC said the Supreme Court was full. But as soon as they won power, they found dramatically or surprisingly 7 empty spaces to appoint justices to the Supreme Court. But because they are doing it, it's justifiable. And if it is being done by another government, it is not justifiable. I have heard radio interviews, and I have watched some of the radio interviews on YouTube, where the chairman of the NDC, Mr. Johnson, Asiedun Ketia, aka General Mosquito, has said that the Chief Justice is a goner. And I'm talking about even before a committee is constituted, even before a prima facie case has been established, even before there is a hearing for the outgone Chief Justice to state her side of the story, they had communicated publicly and given the direction and communication to their allies, their third party, so-called neutral allies and everybody to go out there and say the Chief Justice is a goner. The Chief Justice is a goner. Now the next attention should go to the Electoral Commissioner. I wouldn't be surprised if a fictitious petition, a frivolous petition is filed tomorrow against the EC.
There are some already filed.
And then, yes, and then there will be a charade of another Article 146 hearing to remove someone whose qualification is similar to that of a justice of the Superior Court. But one thing is for certain, most of the people who are having commentaries on these issues have not even read the petition based on which the CJ is removed. Neither have they read her response to the petition and the key issues that she raised in them. I have read the 21-page petition that Mr. Daniel Ofori wrote to the president. And I'm basing my submission on that petition because the committee's work, based upon which the president has removed the CJ, is only dependent on the Daniel Ofori petition. Not the shining star, not the Akologo.
Has been suspended.
Yes. Are you get the suspension as it stands today is based on Daniel Ofori's petition. Daniel Ofori's petition contained 25 allegations. 1 on purported misbehavior and then 4 on stated incompetence. And the petition did not come with any exhibits or evidence, for which earlier on the CJ was contesting why a petition that has gone to the president for him to onwardly forward it to the Council of State for a determination of prima facie case, when the petition does not even come with exhibits or evidence.
One more evidence we need.
I am coming to the substance of the petition for the benefit of our viewers and for the purpose of education. Let's come to the first 3 counts of the allegation that were made against the former CJ. They said the former CJ has traveled to Tanzania, Arusha with the husband on a holiday, on a vacation, and the state had to pay for it. They said the CJ had traveled to the United States with her daughter on a vacation, and the country had to pay for it. They said she has taken a per diem, an impress of $14,000 and failed to retire it. The CJ has come out to say that, 1, the CJ is not in charge of the travel policy of the judiciary. Number 2, the emolument. No, because I'm coming to Article 71. No. For the purpose of education, we should not circumvent any of the parts. Whatever conditions of service offered a Chief Justice is not determined by the Chief Justice. There was a Prof. Abubando committee that did the emoluments of the Article 71 office holders, including that of the Office of Chief Justice. And then there is a travel policy for the judiciary, which is being controlled by the Judicial Service. In all of this, the CJ said, no, it is not true that I took $14,000 and I did not retire it. I retired in excess of $9,000. Number 2, by law and convention, the CJ is entitled to 2 paid vacations in a year. So, and I have heard some of the comments from NDC commentators and their signs, including one video I watched of Ivan saying the Chief Justice and the husband even flew business class. And I'm saying this is the head of the judiciary. If the president can take private jet, can take first class, can take charter flights, we want to reduce the office of the Chief Justice to someone not even entitled to business class ticket. And then people have
its finding.
I am saying that no.
So how
please,
do you justify that?
I am saying that I am coming to what we call threshold. I am saying that if there was an audit finding that the Chief Justice failed to retire the impress, they would have brought a query for which there would have been a search
I think
on that particular count.
Policy that was violated. The money wasn't meant for neither husband nor
I am saying that before 2010, the travel policy used to state the specific individuals, including spouse. After 2010, we had a situation whereby you have a CJ who may not have a spouse, so they added another person. And it is only reasonable that they remove the spouse and replace it with another person, not security. Anybody peddling that they included that she should go with a security is false. It means they've not read the policy. Another person, as a Chief Justice, going on vacation, which she is entitled to, as stipulated in their travel policy, went with her husband. And the argument is that it should be a basis for stated misbehavior and removal. And we say that is
and that's why I was
and now I am coming to I am coming to another issue. As for public travels or official travel, it's unlimited. It's unlimited. There is also an allegation in the Daniel Ofori petition talking about the Chief Justice one, that she has some form of bias in his case with Ecobank. She had an interest of assault, and for that reason, there was a judgment against him in that case. If anybody cares to know, if you go to the Supreme Court, whether they are exercising their exclusive original jurisdiction, whether they are exercising their interpretation and enforcement jurisdiction, whether they are exercising appellate jurisdiction, the CJ does not sit alone. No justice of the Supreme Court sits alone. It is always a panel. If you state that someone has misbehaved because she was a member of a panel that ruled against you, why is there no petition brought against other members of the panel? Because in any case, if there was a panel of seven, if there was a panel of seven, and the CJ had a dissenting opinion, and the other 6 ruled in favor of your case, there was no way the opinion of the CJ was going to override yours. All that I am trying to say is that if you look at the substance of, and I can run you through allegation, responses, back and forth and everything, and tell you one thing, that there shouldn't have been basis for removing the Chief Justice if truly the intention was to protect the Constitution, to protect the law or the judiciary. The only justification is that they had promised that we want to reset the judiciary. We want to remove these kinds of people and bring our kind of people. And we have won an election that has given us overwhelming goodwill. And at this time, even if we do anything, Ghanaians will not say anything. Right. And that we heard that in the time past there was an EC chair who a petition was brought against under Article 146. So this is our time to get our kind of flesh. And for that reason, she is collateral damage for the previous administration. State that. If you say that with your full chest, I don't mind. But to antagonize the woman, to lie on her, to bring frivolous petitions and constitute a committee whose judgment was known even before they started their work. It's unfortunate.
You see, if the Chief Justice is the head of the Supreme Court, but you see, when you say that me and Ivan, we are going to the straight jacket, it means we are touching our credibility. When it is
Nana, you know I love you. But you are a staffer. You speak for President Mahama.
But the point
you don't speak for
okay, so let's
discuss this.
So political highway. So former Chief Justice Torkorno and HS Ordinary case akwakopi more court say a court share na omo ni process ni mu ya abusua enye asem keto akra beda ma asem je pene konkoti sa in some way e de mi aha Ghana Politics Avenue. So abusua unsubscribe ya subscribe like na share ma for front so enter into me and and don't forget to click on the notification bell send be ya any update be drop biano wonso wonsa ebetumi aka medemase.